So if you want to buy more property. So a trust, if you want to buy more property, can buy. What you want to remember is if the trust owns a holding company, which owns trading entities, that's just the typical way we do it. So the trust would own a holding entity which owns trading entities. It depends on what sort of asset we're buying. If we're buying an investment property, then the holdco can buy. And you see the money has moved from, let's say I own Naivas or I own a supermarket called Diamond Supermarket. So Diamond Supermarket is doing all the trading. It does all its revenue versus expenses and pays corporate income tax. And then it declares a dividend to Diamond Holdings, which is the holding company. Because Diamond Holdings owns more than 12.5% of Diamond Trading, Diamond Holdings receives the money tax-free. So when the money now, the investment income is sitting as Diamond Holdings, the board of Diamond Holdings, being the primary holding company for the trust, will be many times a mirror of the board of trustees. This is for governance issues. I'll explain that a bit later. So we can either buy the property at Diamond Holdings level, depending on what we are buying, depending on even whether we're investing in a new business, we can invest the money from Diamond Holdings level to now Diamonds 2, or to buy a property that is either owned by Diamond Holdings itself, or even that is owned by the trust, depending on the nature of the asset we're buying, if we're buying government bonds or something like that. Or we can move the money further again into the trust. Again, as I've told you now, here we pay the 5% withholding tax as it's entering the trust. And then from there will be no further taxes payable because it has entered as qualifying dividend income. So now when it's sitting in the trust, we can distribute. If I wanted to buy a house for a beneficiary, when I'm buying the house, it becomes a distribution to that beneficiary. I can choose whether to register that house in the name of that beneficiary or to hold it in one of these structures within the trust to mitigate any further risk towards that property as well. Okay? So that is the professional service the lawyers here, the wealth attorney here is offering. I hope that is not a lot of commercial and tax law. Are you following? You're following, yeah. If you're not clear, just tell me so that I give you understanding. But yes, so trust, you don't even move all the assets all at once when you create it. We settle them over time. Yeah, and then another mistake I've seen in the practice is people list all the properties behind the trust deed. I don't recommend that because the trust deed will be filed at the BRS, yes? So you are allowed by law to settle in parts. So just settle a little, then the rest we settle by deeds. Uko nyuma, like we'll do it as an internal thing so that when someone searches your trust, they don't just find a list of all your assets. Yes, we are creating the trust to create some level of privacy. Okay? Yeah, so we can settle with over time. And we can continue to buy any type of assets you want. If you want to know the difference, the big difference between trading assets and investment, assets, our current Trustees Act at Section 4 lists investments. So government bonds, all of those other things. But also the easy way to know the difference is to check whether there are agency taxes attached to the income. If you have an income that has a tax like VAT, VAT is an agency or trading tax, that is definitely a trading income. Yeah, but you have an income that only pays the withholding tax. These things that are usually called final taxes, withholding tax, or like now residential rental tax is also a final tax. That's an investment income. Okay. Yeah, and then the other thing is how can we get your rate card for those who need a one-on-one session? Yes, I have given my number, but I am happy. I am a lawyer, like Catherine said, so please give me business. I will appreciate. And somebody asked me if I incorporate trust. I was like, it didn't come out clearly. I incorporate trusts. I create wills. I do the whole shebang. I do tax planning. I am a corporate trust lawyer and tax lawyer and commercial restructurings. We have a team that understands all of that, but I also understand all of that. So if in a will, if something is allocated to the other wife, irrespective of how small, can it be challenged in court or overturned? No. You see, Section 5 of the Law of Succession Act gives something called testamentary freedom. Testamentary freedom means you, the owner of that asset, have a right to bequeath your own assets. You have the freedom. That is why you can wake up today and decide, I am bequeathing all my assets to SPA, the one that picks up the dogs in town, yeah, that one. And then tell my children, especially if they're not below 18 or they're not my nishida yenu, everyone to figure out their own wealth, you know. The law allows you to do stuff like that. But as I told you, in the case of a will, there is a section called Section 29 for dependencies. If somebody can prove that they are a dependent to the court has a discretion to vary the will. So the court can say, by the way, based on the evidence you brought to me, you are a dependent, so I'm varying the will and I'm giving you, let's say it's school fees you wanted, school fees for the next 2 terms. Yeah, and then by term 3, figure out what you're going to do. Or they can vary if they're a child and say, we're giving you 5% of the estate because you need to grow, to cover the time you grew. So you have testamentary freedom. You can give, in fact, this is one of the things that when people are trying to reduce the chances of somebody contesting the will, if a father wants to leave out, let's say, one child, because that child has been rude in their lives or has done something the father considers unconscionable, either you will write in the will the reason why this father is leaving the child, so there won't be issues around it, or you will give something so small, insignificant, just so that it's clear to the court the father knew about this child but did not want him to have a lot. Yeah, so then the court will still adopt it. So giving this second wife for something that could also work. Yeah, but there are better ways around it, as I told you, because the will could be contested. So if we are trying to mitigate the case of another wife sprouting up or other dependents, there are better structures for that, like the trust. And then, do you have to put a figure in your will or just percentages if you're bequeathing cash or cash equivalent, e.g. the value of the bequeathing cash or cash equivalent? The best thing is to state figures. If it's a revolving whatever, let's say it's like bonds, so they're increasing year on year, then it's fine. Say the principal as at this date is that, because the statement will show, and then we'll say based on how it shall have grown, now we will divide 50-50 or 45-65 like that. That is the most important thing. The error we have seen with other bequests is when, for instance, you're bequeathing a company and then you say the company shall go to Diana and Catherine. Now you have not told us the shares. You have to say shares are specific in a company. So you have to say 10% shareholding, or you have to say 100 shares to Diana. Okay? So make sure the will is not drawn in a way that, yes, it's valid, but it's inoperative. Inoperative means we can't follow it to actually achieve the goal you wanted. So which means that that bequest has failed, and therefore that part of that particular fall under the residuary clause. Residuary clause is a clause within the will that says, if there's anything I've forgotten, divide it like this. So you give a formula in the residuary clause. So either it falls under the residuary clause, and if you didn't have a residuary clause, then it falls under intestacy. It's like you didn't bequeath it. So it's best to mention specific the asset, the way it is. And then the other thing is, how do you prepare when you know that your husband has kids outside the matrimonial home? That's a very important question. It starts with ownership. Who owns those assets? And now this one, I will talk for purposes of succession, because for purposes of matrimonial property, actually, let me tell you a story for purposes of matrimonial property. I've been in a case where the wife contributed to a property they acquired with the husband from her. Like they used to be given a golden handshake. So a lot of golden handshake is given. The man had bought a lot of properties over the period of their marriage. By that time, they'd been married for, like, let's say, a significant period, over 15 years or even 20. So when she was getting her golden handshake, she used that money to put it on one of the husband's property. They built a block of apartments. Property boom in Nairobi was just starting. So it did so well, that block of apartments built another like 2 blocks of apartment. So now in total, they have 3 blocks of apartment, and there's enough rent coming in, they're even considering to build. But as I told you, all the initial properties had been acquired by the man in his name. So when she filed for divorce, everything was in the man's name. So the other thing is to first go to the Matrimonial Property Act and state that actually, as much as they're in his name, they're mine, I'm coming to prove contribution. So she was getting divorced almost 20 years after the golden handshakes. So it's going to banks. I think it was Post Bank or a bank that has closed, to look for bank statements to prove how the money moved from here to his account to do the building. She was mostly the foreman because she was reneging. It was such a tough case. But the worst thing, do you know what happened? When he started looking for sure she's going to get the 50%, the man joined another woman to the suit. This is my second wife. Actually, even her, she gave me money to build and to buy the properties as when I was buying. So if you're dividing anything here, divide by 3. There are 3 people in this mix who contributed to this. Can you imagine that? It was so sad. I don't know if the ruling for that case was ever given, but I'm telling you, that was a smart move from a lawyer's perspective, because now he's coming and swearing affidavits and saying, actually, the money you gave is not the only one. Even this one had given this money. So the initial investment is not 50-50. The initial investment is 33, 33, 33. Everyone contributed to this. Yeah, it was such a certain. And of course, by the time he was joining this woman had kids who were old enough to have been born like just after the golden handshake. Like they were just born, they were not at born 2 years before or 3 years. So it had been a long standing. Yeah. So be careful. So the first thing we start with is ownership of assets. Who owns the asset? If you're contributing to the asset, especially if you're making improvements on it or you're doing anything or you're putting your money into something, or if you have accepted, if we have had a conversation, me and this spouse of mine, and said, I'm staying home to take care of the kids so that you work, then let us have a way that my name appears on the ownership document, okay? The risk of appearing as joint proprietors is whoever dies first, the other one gets everything. So God forbid you die first, he gets everything. God forbid he dies first, you get everything, okay? On a joint ownership. So the thing is to ask, so which is the best structure of owning? Owning as 50-50 as tenants in common, everyone would devolve their part, which then would still have the risk of, if he has other dependencies, then coming to share in this 50-50. So in terms of what to own with, holding companies were a thing where you would incorporate a holding company and then I own the shares and he owns the shares 50%. But now in divorces, the Court of Appeal has said that when it comes to a holding company that is owned purely by a husband and a wife, we will interrogate not just beneficial ownership of the shares, we will interrogate beneficial ownership of the property, meaning that they will not allow any spouse to hide behind that this is a company and I own the shares, so this woman does not have access. So that might work to your advantage if you're on that side, but if now you are the one who contributed, it might work to your disadvantage. So what does that leave us with? Leaves us with a trust. So what the trust will do is, number one, if, as I've said, is assets that are owned, are non-trading, you can own them directly in the trust. Simple. The title deed says land in Kwale, the Dianah Mureithi Trust, or whatever you call it. But if it's assets that are trading or assets that you think you're going to sell soon, you can own them in a company owned by the trust. That is what we call a holding company. So the difference here between a holding company owned by the trust and a holding company owned by individuals, a holding company owned by the trust cannot come under scrutiny for matrimonial property. Because matrimonial property disputes, because Section 6.2 of the Matrimonial Property Act. So you'd have the trust own the company own the assets, yeah? But now that's a structure in question. Talk to a lawyer like me, but yeah, that in terms of ownership structures, that's it. And actually on this issue, the Supreme Court has said, the question is not to whom shall I give this property? The question is to whom does this property belong? So lawyers will think like that. They will not be like, it's not like we're here to give you property. We're here to ascertain who owns this property. So ownership, legal ownership is very important. Yeah. Or the other one is, what are your rates? And please share your contact details. I am affordable. Please talk to me. I am affordable. Please take my number. Let us have a discussion. For the first initial session, we usually charge like just 10,000 if it's virtual. If it's in the office and you've come with your documents and everything, we can add a bit more because we can give you advice on the documents you have brought. But I'm happy to have conversations. I'm happy to discuss. I am also growing a business. I'm a partner. Happy to have conversations and discuss how we can help each other, how we can structure your wealth. Then please speak to property you purchased with your divorced spouse and they move on. Does the other family have a right to this property? It is sold. You remember the case I gave yesterday with the second wife who was trying to give him a kidney? Yeah, so it does. It depends on just what improvements are made. The risk here is this. If I purchase a spouse, there's so many levels now. If I purchase a property with my spouse, and then we are China, then that's my spouse lives on that house, then my spouse and his new wife start living here. First of all, this has become her matrimonial home. Yeah, so it has gotten some protections in her favor because that's where she lives as a wife of this man. That's number one. Matrimonial homes are protected at a different level than just normal matrimonial property. Now, number two, if now this is, if she's not living here, but then she comes and let's say they build whatever they're building here, a fence around it, and she contributes money towards that. She has acquired a proprietary matrimonial property interest in that property. Okay? So that also has complicated the issue, which is why in the other thing I was telling you, the guy could go add a third party and say, even this one contributed. Yeah, that is why the court can do that. That's why that person could do that. So if you own property with your spouse and you've gotten divorced, what we're doing these days is property settlement agreements. We don't engage in a lot of contentious probate or family matters because family matters, at the end of the day, we have learned that these people will need to get along at some point when the wounds heal. So what we advocate for is we do meetings until we get to a place where some sort of mediation in our boardrooms until we get to a place where we can do a property settlement agreement. The property settlement agreement will guide us either to separate the property that is subdivided and everyone gets their own property, and there are tax exemptions for property settlement pursuant to a divorce. So we will get tax exemptions. There will be no stamp duty payable and no, there will be no CGT payable. And then if that's not the case, a model that I've seen working is we convince both people, look, fine, you guys can both not agree that the property comes to you or you divide or whatever. So let's create a trust in favor of your children. So then we move the asset to be owned in trust for the children. So each spouse knows that it doesn't matter who you get out there and who the other one gets out there. Neither is going to carry this away at the end of the day. It's going to be for the benefit of the children. And this works very well, especially for younger couples between 30 to 50, because we've seen people at that age divorcing a lot. So what we will do is would create the trust, and then within the trust we would create an education fund and say that one of the goals we are doing is an education fund. So if we have 3 children, I have 3 children, we'd say the targeted education cost for each child is, let's say, 20 million times 3, 60 million. The initial asset we have is our home. So the home can be moved into the trust. As long as I'm living with these children as a primary guardian, the trust allows me to continue living there. But it states that if I remarry, I must exit. So if I get married now, I must exit. The home is rented as one of the assets for this trust. And then that rent continues to compound to this other figure we were creating for the education fund. So if all of us were contributing, let's say 100,000 towards the fund, now the 100 for me and him, then the rent from the house continues to compound. So you see also we've created a way that there would directly be a benefit to the children without me and my ex-estranged spouse needing to talk to each other all the time, and without him feeling that I am the one benefiting or the money is just coming to me and there's no accountability for it. So we would structure it such that we'd have an investment advisor. The money would be invested either, let's say, in the stocks or wherever, or bonds or whatever, but it has a goal. It needs to get to at least 60 million in 10 years so that the children's education for university is covered. And then usually we will provide for a clause that says once the youngest turns 25, the house can be sold, everything divided by 3 among the children. We've done this a lot even for men with second children out of wedlock who are not having continuing relationships with that mother, because we just need to secure how that child born out of wedlock would endelea kusoma if the dad died, and also how we would keep these persons from needing to constantly be in communication with each other. Okay? Yeah. I hope that is clear. You don't look like you're getting clarity. Yeah. So, yeah. In a will, if something is allocated to the other wife, irrespective of house more, can it be challenged? I think we've answered that one. Do you have to put a finger in your will, or just pass a figure of a figure? We've answered that one. What are your rates? We've answered that one. How do you prepare? It has kids. The last one, yeah. So the last one is it's a bit long. Hi, we're a family of 5. The late father, mother, sister, then late brother, and myself. So the father and the brother are deceased. So 2 sisters and 1 mother is remaining. We have successfully finished succession of my late father's estate. These are my mother, my sister, and myself are now the administrators. My late brother had a girlfriend who they bore 2 children, 12 years and 13 years, but never officially married, no marriage certificate, and was separated for 5 years before his death. And at this point, there was another case between them where she fled the home and much later came to kidnap the children without my late brother's consent and disappeared with them. This matter also went forward to court. We, the remaining living, have included his 2 kids in the succession process and grant awarding, as we are the administrators of the estate, and agreed to hold our late siblings' share of Mze's estate on behalf of his minor kids. We have been taking care of my brother's children, paying the fees, paying the rent in Syokimau, insurance, cover, upkeep, and food. We have produced all the receipts, and since my brother's death, this was initially accepted by the court, and the court was to sign. However, last-minute application of the mother has come, as she has an affidavit. She has on affidavit lied that we have abandoned the kids and have never done anything for them, and as such should be given the sole right to my late brother's estate share. So this we have countered with all the receipts mentioned above and falsifying her claims. Further to which she even tried to bring in section 40 of the law of succession polygamous one for a man who's polygamous. This we were advised by our legal that it doesn't even apply. Question is how would this possibly end seeing who are listed as administrators to be given the share of the last late member of the family and his children are listed on the grant? Okay. This question has a lot of complexity. First, what do I want to start by saying? This one I say not as a lawyer, but as a human. The children who are born in all these other marital relationships, in my own opinion, you don't have to take it, never consented to be born. They don't consent to be born. You are mad, you're angry, we understand. Vows were broken, we understand. But the sooner we accept that this person didn't ask for this, the sooner we create a solution that allows us to move forward. Yeah, we can't keep crying over spilled water. Okay. So the first thing I usually advise clients is let's just accept. Let's also see that this child will be protected by under both the Children's Act and the Law of Succession Act, and there will be an obligation on his parents to provide. So that's number one. I want to say if you're in such a situation, just start finding a way to accept that. Then when we accept, we create a provision for them that you're comfortable with from his assets. That's number one. Number two, when I was pointing out yesterday the situation of grandparents who sometimes are blackmailed because of a lack of access to a direct nexus to the children. This is it. You see how that these people are providing, they're doing everything, but they don't even have a direct. If this person wakes up and takes her children, they're her children. Other than if under the Children's Act, if I live with a child for 3 months, let's say I live with my sister's child for 3 months or more, my sister cannot take her back without my consent. I have a right to go to court now and say I was the one taking care of this child, but I'd have to go to court. So if this was an ideal situation, we would have advised the brother before he died to first leave her at least a will or a trust that is stating guardianship. That would have been an ideal situation because that would have given these people a direct link to these children and a direct basis for holding their assets. That being said, even as currently, as she says, your case will win if you're here. Your case, I think, is strong. You will get the upper hand because you just need to demonstrate proof that you have actually been doing that and you say that you have the receipts. So that will be there. I would go a step further and pray for guardianship documents, especially if you're the one living with these children. If these children are living under your care, you can move under the companies, under the Children's Act now, if you've lived with them for more than 3 months, to ask the court to appoint you as a guardian. That does not mean you're becoming a parent. A guardian is different from a parent. So having a guardianship application is a guardianship appointment will give you strong basis. You won't be thrown around left, right, and center based on the whims of this mother. So that's number one. But beyond that, if you're not living with them and cannot have basis for making an application for guardianship, the receipts you're providing are important. They will be proven. There's already a case by Justice Musyoka again that states that grandchildren don't rank at the same level with children. So there'll be no basis for this woman who's not even married, even as their guardian, to come and sit as an administrator and hold these assets in trust for these people. You guys are likely going to be confirmed unless evidence can be presented that either you're fraudulent or you're acting in a manner that is to the detriment of this child. So if there's such factors don't apply, you will likely be upheld as the trustees for these children until the children turn 18. Now, the only question is, turning 18 is rarely ever a time when a child can make very good decisions. So we may still pass on the assets at that time and the mother still convinces them to do some crazy things with those assets. So my advice is usually to start contemplating a structure today, a structure that would work for those children, like now the one I've explained through the trust or something. But beyond that, I think everything you've done will allow you to win the case and to get that. And I agree with your lawyer, because we're dealing with the estate of your father, not this man, not your brother. There's no polygamy issue here. The issue is there's no polygamy because you're dealing with your father's estate. For this woman to even come, she needed to have gotten the grant of your late brother's estate. And the cases you mentioned in court where she had left, she had kidnapped, those are all cases that prove that she would not be a fit administrator for this estate. Because if during life you are warring with each other, what is this now that you're going to do it? You're going to stand for his whatever's after death. And in fact, an easy argument with such women is always there is a pending case, let's say, on these things. If a grant ad litem was to be issued, will she be the plaintiff versus herself as the defendant again? Like, she cannot be both. She cannot act for the deceased person as plaintiff and then defend against herself because she's she's the plaintiff in this. She cannot be the plaintiff and then defend her herself on behalf of this man as a defendant if there's a substantive suit that has continued post his death. Yeah. So I think that is it. Those are all the questions. Thank you very much.